SJC-13576, Kenneth Bresler versus Lynn et al.
Okay, Attorney Bresler.
Chief Justice and Associate Justices, may it please the Court. I'm Kenneth Bresler, plaintiff, appellant, and cross-appellee in this case. I will be referring to myself in the first person. The first point I want to make is to amplify on something in my briefs, namely that an iota of legitimate government interest does not insulate supervisors from liability. We know that from a few reasons aside from what I've mentioned in my briefs. The first is the controlling factor inquiry. That implies that other factors can coexist with malignant, spiteful purpose, such as a legitimate governmental interest. Another way we know that is the Sklar case, the appeals court case that I discussed in my briefs. The Sklar discusses a spiteful, malignant purpose unrelated to the legitimate corporate interests of the employer, the familiar formula, and then says, put differently, the defendant was personally hostile or harbored ill will toward the plaintiff. The Sklar case provides two alternative definitions of actual malice that do not include legitimate governmental, corporate, or employer interests.
It's difficult to find, and this might be in your favor, but it's difficult to find 12b6 cases in this area. But you discussed two of them, or looked at two of them that I'd like you to distinguish if you can. The first is the Kelleher case from the appeals court, which you talk about. But the second is the First Circuit Nahas case, realty case, because both of those cases seem to me to say if there's personal animus that's unfortunate but not actionable, we need to have something more than that. So could you walk me through Kelleher and Nahas if you can?
The Kelleher case is distinguishable from this one. Again, it's as you said, a rare appellate case at the motion to dismiss stage. Kelleher, the complaint in Kelleher provided legitimate employer interest that the Superior Court could look at and ultimately the appellate court. There is nothing.
But in your situation, reading the complaint in the light most favorable, there are interests that are vindicated, in the 13 points, etc. There are reasons given for the termination, correct?
Yes, there are.
That are related to the appeals court interests.
I don't see a legitimate interest in the appeals court in its supervisors fabricating evaluations of its employees such as me, and I don't find a legitimate interest of the appeals court in artificially splitting two minor errors into two charges to increase the number of charges when those errors are similar to ones that other employees of the appeals court and judges themselves unfortunately make. The editing process is predicated on the principle that humans are human and make errors, and the process is designed to catch them. Not all errors are caught. And my opposition to the motion to dismiss has a footnote discussing errors that made it into published decisions of appellate courts.
Okay, and I interrupted you when you were distinguishing Kelleher, so please continue.
That is the main distinction with Kelleher, is that the complaint in Kelleher itself undid itself by discussing things that the appellate court could extract from it to discern legitimate governmental interest. The Nahas case that you asked about, because it's about real estate, really is hard to compare to the workplace and animus by supervisors towards an employee. And that is the major distinction that I would make.
There's a line in Nahas which struck me as problematic for you. says the rule is that there is every presumption in favor of the honesty and sufficiency of the motives actuating public officers and actions ostensibly taken for the general welfare.
There is that presumption. Of course, that presumption can be overcome by actual malice, by bad faith in malice. And I believe that in this case, the things that the defendants have done overcome that presumption. I think that the complaint plausibly alleges that they were doing things for purposes other than legitimate government interests and the interests of the court. My complaint plausibly alleges 5 times that the things that the supervisors did, the defendants, actually hurt the legitimate interests of the appeals court.
Can you divide up? I'd like to focus on.
Yeah, please.
I'd like to focus on Bo and DeRossi, because I have trouble identifying anything plausible there. I get the other is different, and I'm not focused on that right now. So tell me, what Bo gives a very positive evaluation of you.
Correct.
When she starts. So she clearly has nothing, there's no ill will in the beginning here. What happens later, I understand you think she got some of the disciplinary descriptions wrong, but I don't see a lack of good faith here, or actual malice. So show me how, what is it that she has done? And then I want you to refer on, again, for DeRossi, and I'd like to turn to paragraph 78 eventually, but tell me about DeRossi and Bo. What is there besides the fact that you disagree with the evaluation, the specifics of the evaluation?
Whether or not Bo and DeRossi had personal animus to me, they did demonstrate bad faith, which stripped them of common law immunity. What Bo did was fabricate evaluations against me in verifiable ways.
She doesn't do the evaluations, right? She's not providing the material for that. Someone else is providing them. I assume Muster is providing that to her. Is that right? I don't understand what she's doing that's besides getting the facts, some of these facts wrong, according to you.
A reasonable inference from the complaint is that Muster is giving information to Bo and influencing her. But Bo is exercising independent judgment by giving me oral evaluations and written evaluations that contain verifiable fabrications that can be checked to see whether they're accurate. And if she's getting them from Muster.
Give me a specific example besides the IT problem. Is there, explain the specifics of why it shows bad faith. Because again, it seems like you disagree. Okay, you didn't edit something as well as they thought it should be. And you have a disagreement about the facts. It doesn't show ill will, though.
The verifiable errors, besides blaming me for a computer error, are blaming me for an error that another employee did and that Bo, as chief staff attorney, knew was not within my purview as a staff attorney.
Give me an example of that. Because your complaint is chock full of a lot of detail, but give me an example of what she did that shows bad faith, because I have trouble. And you're going to have to articulate it. Just because you think it wasn't accurate, that a judge was somewhat more positive than that description, help us out.
One of the charges against me was that I made an error in a rescript cover, which I, as a staff attorney, had nothing to do with. And Bo, as chief staff attorney, knew that that was not within my purview. Another allegation that originated with Bo was that I included objectionable language in a case, in a draft, that did not include that language. I think that's a clear example of bad faith to to fabricate evaluations that can be verified. Those are my examples from the complaint. As you mentioned, the complaint is detailed, and I think it adequately demonstrates bad faith malice.
I have the same confusion. So is it that these were things that were easily verifiable, and the bad faith is in not unearthing that they were wrong? Stated differently, are you saying that bad faith is demonstrated for not only Bo, but also for DeRossi in not doing a better investigation?
I'm saying more than that. So for the complaint plausibly alleges not that Bo and DeRossi got information that was incorrect that they incorporated in their evaluation and charges against me, but they fabricated the evaluations. So if Bo got incorrect information from Muster, first it was bad faith in relying on it because she knew that Muster was a inaccurate reporter. I had already asked Bo to be protected from defendant Muster. The union steward had told Bo that Muster was bullying me, and it would be bad faith for Bo to accept information from Muster.
Isn't it more attenuated when it gets to DeRossi as well?
It is not as direct with DeRossi as with Bo, but there's still enough in the complaint to strip DeRossi of common law immunity and her protection as a supervisor. Because what DeRossi did was adopt fabrications 3 times. Once by sending them to me.
If she supervises the other supervisors, correct?
Yes.
Your position is it's bad faith because she didn't look underneath what Bo and Muster told her? What Bo told her, who was told by Muster?
It was bad faith for a couple reasons. One, she did not give me access to my files to allow me to refute the charges. She was interested in terminating me, not in learning the truth of her charges against me.
That's sufficient to negate common law immunity?
Not sufficient by itself.
The rebuttal process?
Not sufficient in and of itself, but combined with other factors. So, for instance, the outside consultant that the appeals court brought in to evaluate staff attorney operations advised the appeals court to bar DeRossi and Muster from working together because they were intriguing against staff attorneys. If DeRossi relied on Muster for information, that was bad faith because...
That's paragraph 78. That's the only thing I see about DeRossi that isn't basically that she didn't have 2 levels of supervisors between her and the information. And is that a quote? I mean, it's not quoted. I'm just trying to understand what we do with paragraph 78.
Paragraph 78 is a plausible allegation that DeRossi was not supervising in good faith, that she was inappropriately relying on Muster and intriguing against staff attorneys, trying to undo them rather than seek the truth about their accurate performance.
Yeah, I have problems because you keep using fabricating, intriguing. If intriguing were in quotes, I'd have some more concern about it, but I can't tell whether, again, it's a characterization from you.
It is a characterization. The complaint does not contain any quotation from a report from the consultant or lead one to believe that a report was ever released.
So what do we do with that? I mean, we're at a motion to dismiss stage. I can't tell whether the word intriguing is a factual or an overlay from you.
Well, What I hope this court does at this motion to dismiss stage is what the appeals court said in Freilich versus Perkett, which is the tortious interference claim requires an assessment of the state of the mind and should be evaluated on the basis of a factual record. And the factual record would also include finding out more about an objective outside observer's assessment of how the appeals court was treating its staff attorneys and what it was allowing its supervisors to do.
Okay, thank you very much.
Thank you.
Attorney White.
Justice Spud, Associate Justice Gaziano, Associate Justice Capker, Associate Justice Georges, how are you? I have the privilege of representing Lynn Muster in this appeal. I am an appellant, which is somewhat unusual, and we're asking the court to overturn the decision of the trial court on the issue of common law immunity, but also on the, if not, on the issue of the intentional interference with the advantageous relationship claim. Some of the questions that the court just posed to my brother deal almost exclusively with the arguments I intended to make. When you look at the complaint, it is very detailed and very thorough, but it's from its absence, you can see that there are no quotations to some of the allegations against specifically my client. The complaint that Mr. Bresler has filed only talks about my client's conduct in detail on 3 pages. There's only 13 paragraphs. Then it goes on to talk about the conduct of Mr. Rossi, Ms. Bowe, and spends 9 pages defending the 13 items that he was terminated for.
I think what's problematic are paragraphs 38 to 41 that deal with, there's an allegation of bullying, but then when you read paragraph 39 and 40, it talks about your client soliciting 2 judges to turn against the plaintiff. So is that enough?
So it's not enough, and here's why. First, this goes to what you were saying earlier, these are labels. At least there's a bullying label, there's a jealousy label, there's no context given whatsoever, and he had the opportunity to do that when he pled. He could have quoted something that she said, he could have provided a specific circumstance, but he doesn't do that, and that's his burden here. He can't just say, my superior bullied me. He could say, my superior bullied me and did the following, but he doesn't do that. He could say, as he does, that she spoke with judges and that judges thereafter provided negative comments at her direction. But on that point, we have to look at the plausibility issue, right?
So, I mean, I know there's separate analytical pathways here. We have the 12b-6 and we have the common law immunity, but there's a lot of overlap.
There is.
In those two areas. What's your best case as far as these conclusory language labeling that means that would allow you to win before discovery?
The best case that prevents someone from just providing labels to.
Right,
I mean,
right.
It's the Iancino case, which is kind of the basis for all 12b-6 arguments.
Right. I meant specific to this tort.
Specific to this tort?
Yeah.
I think that's it. It's cited in several of the other cases.
No, I mean, you're citing to us just the 12b-6 standard, but I'm looking to see if you have a case you can direct us to that deals with the tort of advantageous relationship and sufficiency on mere labels and conclusory language.
Well, I can go through the cases that I think support my client's claim, and most of them, whether they're 12b-6 or not, look at the conduct. And that when they look at the conduct, they look at the conduct of the individual.
Because that's why I started with Kelleher in the
Yep.
Nahas case, because those are the only there's a strength site in one of the briefs, but a lot of them are trial court decisions. The only cases I found were helpful to me were Kelleher and Nahas as far as that stage.
You're right, Your Honor. We've looked, that really is it. And that's why I think you have to look further to the cases that involve summary judgment. And when you're actually looking at what's being pled and what the allegations are, do they state a claim of actual malice? That's what the court's doing, whether it's at 12b6 or even at the summary judgment stage. And the cases that specifically the trial court relied on are very distinguishable from this. The Brothers case versus Milbury, which is the primary case that the trial court relied on, talked about a twisted investigation. It talked about destroying evidence and making false public charges against this contractor. That may be the type of conduct that is actual malice, but it's not similar to the type of conduct that's alleged here. What you're seeing here is conduct of a supervisor performing their position, and we see through the 9 pages of back and forth about the 13 items that Mr. Bresler was terminated for, that he disagrees with those.
But I know you remember this better than I do. What was the procedural posture of Brothers?
Brothers is a U.S. District Court case.
Where were they? Trials, summary judgment?
They were at summary judgment.
So, I mean, that's the real issue here, is that, so they were able to develop a discovery record before that decision came. Here, maybe not so much with Bowe and DeRossi, but there does seem to be direct factual allegations that seemingly support that your client had this vendetta against the plaintiff. And I agree with you, there are no quotes in there, there's no report, but at least in as much as the substance of what he claims, that the relationship deteriorated, enough people, including the shop steward, were cognizant of this, and that it imputed all the way down to other supervisors and other judges. There's not enough here against your client. I know you're going to say yes, but leaving aside the kind of adversarial gloss, isn't there really enough here?
Well, I think the answer is no. And yes, they did have the opportunity to do discovery in many of these cases, but you still have to look at the conduct. I mean, that's what we're talking about. The cases support, the cases, specifically the Brothers case, I think supports my client because they are very different. We've cited to multiples of other cases that the conduct is, it's either illegal or it's suggesting illegal conduct. It's terminating someone for not following statutes and rules and regulations. None of that is in this case. In our case, this case is about an employment decision that was made by the appeals court and other supervisors. If you look at the language in the complaint, it's not a claim against. My client wasn't involved in the termination. He said to you today that there is an inference that she was involved in it, but there are no facts, and he spends more than 12 pages in the complaint talking about that termination. He says there's an inference that you have to adopt.
She's the direct supervisor, though, right?
She is a direct supervisor of certain.
I mean, almost the whole complaint is suggesting that she's. One, she starts out weighing in on whether he should teach a seminar or not, which should be none of her concern. Then I don't know what this taking over thing means, but it seems to be a quote rather than it's different from sort of just a pure characterization, right? And then we've got statements by other attorneys, including the union steward, that talk about personal hostility. It just seems different here, doesn't it? Then I don't understand how we can ignore all those comments.
Well, I'm not asking you to ignore them. The trial court identified 7 issues that, taken together, the trial court found that there was enough. Trying to take over statement, I don't know what that was, but it doesn't sound to me like malice or actual malice.
But it's just strange that you've got one staff attorney concerned that another staff attorney is teaching a seminar on legal writing. Well, I get it if Bo decides the writing is not good down the road as the manager of the department, but it seems a little different when another employee doesn't think it's appropriate, right? It just seems different.
But it may be different,
Well,
something that
more-
we've not encountered, but it doesn't mean that it's malice
But
or
if
actual
they're not doing
malice.
their job. What's the relationship between her job and whether he teaches a seminar at social law?
Well, he says in his complaint that she failed to publish information about his CLE program, but published other,
It's the second one.
that's the second one,
The
yeah.
first one, he's suggesting this starts right in the beginning, before she's a manager, that it's personal.
Well, I suppose, I mean, that the manager sees the writing and it's a course on legal writing and possibly thinks the
She's
individual
not
is.
a manager at that point, right? She's a co-employee. She's just another staff person then.
Well, that's in the first several months of his employment based on his complaint. I mean, the term, I don't know how you can relate back that comment before she's even a manager as a co-employee to a termination that occurs 18 months
He
later.
relates back and he says she's jealous of, I mean, whether any of this is true,
Yeah, of
it's
course.
too early, but he suggests that she's jealous of the attention he's getting, that he's speaking out there, and then she goes out to undermine that. And then when she becomes a manager, she's empowered to do it. Again, I have no idea if any of that's true.
Of course.
But it's early in the process.
He labels it as jealousy. He labels her conduct as jealousy. I'll point out,
But he quotes other people too, doesn't he? He says other staff people are making the same comments.
I don't think that that's accurate. In the, and in particular, footnote 3 of the lower court's decision talked about the jealousy, said there was no evidence of jealousy that he pled in his complaint. So I guess if we're reviewing the decision of the lower court, is that there? I know that's a de novo review, but she says in footnote 3, despite saying there are 7 facts that she could find taken together plausibly support his claim.
Again, I just want to, 31 and 32. Staff attorneys widely considered defendant Muster to be vindictive and petty bully. Staff attorneys widely considered defendant Muster to be jealous of attorney Bresler's achievements as a legal writer and teacher. We do what with those?
Those are labels. Those are labels.
They're not statements of fact that we need discovery on later.
They're labels and they're conclusions. I mean, it's generalization about staff. There's a room full of staff attorneys. He identified judges. He identified Judge Blake and Judge Hand in the complaint, and said that my client unduly influenced them to provide negative support, negative criticism. But he doesn't do the same with these generalizations, and that I think is the problem.
Perhaps with the jealousy one, but when you go through, and I agree with you, if you were to take them in isolation, perhaps none of them get over the hump. But the trial court judge, or the trial judge said, the taking over, soliciting to other justices, disparagement in front of other staff attorneys, discouraged staff attorneys to attend his seminars, refused to publicize his seminars, influenced him to give others poor evaluations, subjected him to impossibly high standards. When you take all of those together, I'm still struggling to see how that doesn't plausibly, under the Iankino standard, say he at least gets past 12b-6 in common law immunity. He might not get past Rule 56, but how does he not get over that hump?
Because I think what you're looking at, and 2 of those were disparaged, okay? There's no examples in the complaint at all, no factual statements, other than she disparaged me in the complaint to judges and to staff attorneys. There would have to be more.
So it would
Otherwise,
have to
it's a
be,
label and a
give me the time and what he said versus just putting a conclusory label on it.
Anything. He hasn't provided anything and if you take the disparagement, the 2 claims about disparagement out of those 5 items, then you're left with conduct that would reasonably be occurring and supporting the legitimate interests of the Commonwealth. Also conduct that a supervisor might undertake in this position. We're talking about legal writing for the Appeals Court of the Commonwealth of Massachusetts. The fact that my client, her reviews of his writing have been labeled as brutal, without more, it's exactly what I'm saying. It's a label and it's a conclusion. Thank you for your time.
Thanks. Okay, Attorney Collins.
Good morning, Chief Justice, Associate Justices. May it please the Court, Jeffrey Collins for the appellees, Gina DeRossi and Mary Bowe. The parties don't disagree on the applicable standards here. It is plaintiff's burden to overcome the presumption that Ms. DeRossi and Ms. Bowe acted in good faith and without
Can I
malice.
get to the easier one on DeRossi? And Justice Kafka pointed out the paragraph that talks about the consultant and the intriguing against staff attorneys. How do you get around that for 12b6 or immunity?
Well, Your Honor, I believe that Mr. Bresler just admitted to the Court that this was a characterization of his own, not a specific allegation against Ms. DeRossi. Also, it's a generalized conclusory statement. He says simply, and again, it's not a direct quote from a report, it's not a direct quote from Attorney Damon. He says generally and conclusively that these two individuals were intriguing, whatever that means, intriguing against staff attorneys. It says nothing at all specifically about Mr. Bresler. And so,
It does reference a specific report, though. It's right? It just, that makes it a little odd. It's not, this isn't just an allegation, okay, that DeRossi and Muster are intriguing. It's this outside consultant found they were intriguing, right?
yes, Justice Kafka, but again,
No discovery, nothing. I understand it's not in quotes, but it's more than just, it has some kind of factual level to it.
I respectfully disagree. I mean, I think it is a conclusory statement. I think saying that two staff employees intriguing, again, whatever that means, because Mr. Bresler doesn't tell us what that means, whatever that means certainly does not rise to the level, it certainly doesn't plausibly suggest. It's not a specific fact that plausibly suggests bad faith or malice, and it certainly doesn't plausibly suggest actual malice. Again, it's a conclusory statement.
Your position is it's doing too much work in this complaint.
I'm sorry?
It's doing too much work, that one paragraph, to satisfy 12b6, correct?
That's right.
Or immunity.
That's right, Your Honor. Correct. So again, the parties don't disagree on the standards here. The standard for actual malice is clear. And again, there are simply no specific facts, right? It is the plaintiff's burden to plead specific facts plausibly suggesting bad faith or malice.
Well, what about, it's hard enough being in a position of being at will, and you're alleging you were wrongfully terminated, and the sequence of events are kind of like almost like Russian nesting dolls, right? That begins with Bresler, and then it goes to Bowe, and then it goes to DeRossi. When you get to the point, though, of saying they didn't, in good faith, investigate whatever it is they say I did, and when I tried to get my file to respond or be given an opportunity to respond, can't we, in drawing all reasonable inferences in favor of the plaintiff, say, well, you didn't give him an opportunity to respond to these 12 or 13 things that you say you warrant your termination, and when you go one step before that you'd inadequately investigated to begin with to even rely on these things that you're not giving me an opportunity to respond to?
This court and other courts have repeatedly said that, and we cite to the Bach case, the Issa case, Nasir, Gregg, and Graham, that unreasonable action without sufficient diligence does not rise to the level of bad faith or malice.
I asked the same question that I asked Attorney White. What procedural posture were those cases? Were they 12b6 cases?
Some of them were, Your Honor, and I can, the Bach case was a motion to dismiss that was allowed. The ISA case was a motion to dismiss that was allowed.
That's helpful, thank
The
you.
Nasir case was a motion to dismiss case. The Gregg case was a motion to dismiss case. And the Graham case, which is a case from this court, was a reversal of a judgment, trial court judgment, where all the facts were developed at trial. Reversal of a trial court judgment in favor of the plaintiff. So,
Thank you.
How about, I'm reading through the complaint. I think, does the complaint say he's the first staff attorney ever fired from the appeals court?
that is the allegation.
So, first, and then I look at these 13 things, and a lot of them have to do with editorial conventions. I don't know how many of them are 128s, whatever the new rule is, what it's called. How long did he work there?
He worked just shy of 2 years, Your Honor.
So he works there 2 years. They identify 13 sort of disputed, and a lot of them are editing. I can't remember how many of them are actual writing. And this is at a time when the appeals court transitions from having specialized editors to having the writers do editing, right? Is there a fair reading of the complaint saying, okay, this, especially when I look at the statement, Bo, it's taken on a life of its own, that this is like a personality dispute between two employees, and they just can't keep them together there because they're scrapping with each other. Is that a fair reading of this?
I don't believe it is, Your Honor. And first of all, there's no allegation in the complaint.
Again, let's start with the premise. No one's, again, I've got to accept this is true. No one's been fired as a staff attorney there, ever.
Correct, Your Honor.
And I look at these fights, and they're murky, and often about trivia, right? I mean, a lot of them are editorial errors or corrections that happen all the time.
I don't believe that's true, Your Honor. And I don't believe it's accurate to say that most of them are about editing. I don't think they are.
Is that right? But tell me, I mean, there's 13 of them, and it was painful to try to go through them, but a lot of them seem to be editing conventions. No? Okay.
I don't believe so, Your Honor. I think the bulk of them were critiques and criticisms from the justices, from no less than 4 justices, about draft decisions that
So
Mr. Bresler.
Again, we've got a record we have to read in the light most favorable to his
Don't we have things like, there was a docket number that wasn't right, there was a snapper that said judgment affirmed as opposed to judgments affirmed?
We do.
If I get graded on my snappers, I'm in trouble. I can tell you that. So, I mean, a lot of these things are, like you said, editing conventions.
Judgments affirmed versus judgment affirmed. We've got where the judges are brought into the mix. He's saying that the judge also complimented him on the decision as well as there's some criticism. And again, we're at a immunity stage.
There's more than that, Justices, and I'm happy to go through it. And this isn't me characterizing the claims or allegations. These are the actual claims in the complaint. Ms. Bowe critiqued Mr. Bresler about a draft opinion that he had written for Justice Maldonado, in which Justice Maldonado complained about to her and called that draft opinion unusable. That is not insignificant.
Doesn't he have a response to that she actually complimented him on that? And that she's criticizing something that Maldonado's law clerk wrote, not that he wrote? There's an explanation here. I don't know if it's true. Again, I have no idea who's telling the truth.
What the explanation is, Your Honor, is that the beginning part of the draft opinion that Mr. Bresler wrote, that Mr. Bresler passed along to Justice Maldonado, right? There's a beginning part of that opinion, he alleges, that was written by a judicial clerk.
I thought, yes, the beginning is written by a judicial clerk.
Correct.
The judge asks him to step in, right?
That's correct. Mr. Bresler is asked to step in on an opinion that was written by a judicial clerk. Mr. Bresler steps in writing that opinion. He then drafts that opinion in his own pen and includes, Your Honor, includes the unacceptable language, the unusable portion, or maybe even more of the decision was unusable, but certainly includes a part of what the judicial clerk had written, which was unacceptable, and then passes that along to Justice Maldonado. At that point, that's his work. I don't think at that point you get to say to the justice,
It's the judge's work.
I'm sorry?
It's always the judge's work. It's not his work. I mean,
Okay.
Ultimately, the judge is responsible for the case, right?
Certainly, certainly. But at that stage, Your Honor, the judge is relying on Mr. Bresler, right? The draft opinion has been passed off to Mr. Bresler to fix. And what he does, and again, this is in the complaint.
This has to do with proper motive to terminate.
Absolutely.
Whether it's the judge's work or not, if he's passed along bad information, then.
That's right, Your Honor. That's right. There's more that rises above the level of sort of the.
But some, like the 13 points, when you go through them, and the 13 points is significant, I guess, because that's the coup de grace, right? That's you're being fired for these 13 reasons.
I mean, certainly it was a culmination, right? I mean, there was a year period that was going on.
But if a staff attorney says that a docket number is 237 and it's 238, I don't think that's grounds for termination, is it?
It's not, but those aren't the grounds that were used. There are 13, and actually within the 13, even more grounds that are much greater than making a mistake on a rescript cover.
But we don't know how the other staff attorneys perform, whether they make these kinds of mistakes too. I mean, again, that's why you have an editor, a staff writer, then there's an editor, then it goes to the reporter's office, right? All those, at least on published decisions. So there are many levels of checking going on. But we don't have any sense of whether this is disproportional to the number of mistakes other people make there either, do we?
There are no allegations in the complaint.
But isn't that why we have discovery?
No, because the reality is what's pled by Mr. Bresler is not sufficient. They're not specific facts that plausibly suggest bad faith or malice. That's the standard here. Common law immunity is there to protect public employees, right? Not just from liability, but from suit. And when you look at the allegations in the complaint, we see that they just simply don't rise to the level of bad faith or malice, and certainly not to a spiteful or malignant purpose.
But if we don't know how his performance compared to the other staff attorneys, isn't that information we need to have? I mean, he says that he was being judged unfairly. Don't we have to take that as true?
I don't believe so, Your Honor, because if you look at the four cases that Mr. Bresler cites, all of which pass the case through where there's a finding of actual malice or a finding of bad faith or malice, there's one common thread through all four of those cases, right? The Brothers case, the Falcon case, the Freilich case, and the O'Brien case. One common thread, and that is some level of personal vindictiveness, personal hostility.
Another common thread, though, is they're all summary judgment cases.
I don't believe they are all summary judgment cases, Your Honor, and I'm happy to take a look at them.
We can do that. I don't want to.
The
I don't
Brothers
wanna
case
ta- I
was a
don't wanna
motion
ta-
to dismiss.
Okay, thank you.
But there's one common thread through all of them, and there's some level of personal vindictiveness, some level of personal hostility, personal animus, and a retaliatory motive. Each of those cases have a retaliatory motive embedded in them. You don't have that here by Mr. Bresler's own admission, by his own admission. We can't say that about Ms. Muster, right? There are claims and allegations against Ms. Muster of personal hostility, animus, vindictiveness, being petty, and the like.
Can we read his complaint as saying that your clients are relying on Musters for all of this information or not? I mean,
In part, Your
With,
Honor.
with knowledge that Muster has it out for him.
In relying on Muster in part, but what is very clear, and by Mr. Bresler's own admission, page 45 of his reply, is that they're also relying on information that's coming directly from the judges, no less than 4 judges. And taking that information, relying on that information, and doing their job, and presenting that information to a
The
staff attorney.
judges are presenting it to whom?
Mr. Bresler. Mr. Bresler, that information is coming from the justices to Ms. Bowe, principally, right, initially, and Ms.
So the judges are not communicating through Muster, according to your reading of the complaint. They're communicating directly to Bowe or DeRossi, or I just want to make sure I understand that.
It's not just my reading of the complaint, Your Honor, it's what Mr. Bresler alleges. He alleges that Ms. Muster went to the justices and asked them to pass information along to Ms. Bowe about Mr. Bresler's performance. So that's not just my reading of the complaint, that's the actual allegation in the complaint.